But my job as President of the Human Rights Commission was to hold the government and the private sector to account for compliance with the international human rights treaties, which Australia had accepted, signed and ratified from those early days, and many in this audience will know this well, of that remarkable, feisty, brilliant lawyer, Dr. H.V. Evatt, who went to the Dumbarton Oaks outside Washington to negotiate the Charter of the United Nations, which linked, for the first time, the need to respect human rights with world peace. That was the underlying aim of the Charter of the United Nations. He was asked back by Eleanor Roosevelt to help to draft the 1948 Universal Declaration on Human Rights, which passed under his presidency of the General Assembly without a single negative vote. That was a remarkable achievement, and he set the foundation for what became Australia's very strong role as a good international citizen, all the way through the development of the modern treaty law, right up to the creation of the International Criminal Court in The Hague. We have the Refugee Convention, many of you will be familiar with it, the Convention on the Rights of the Child, the International Covenant on Civil and Political Rights, the Race Discrimination Convention, the Sex Discrimination Convention, and many, many, many others. All of them were a statement by Australia that we stand in the international community as committed to fundamental human rights. So they were important years, and that was my job, really, at the Australian Human Rights Commission, to hold the government and the private sector to account for compliance with the major ones of those treaties, particularly the International Covenant on Civil and Political Rights and the Convention on the Rights of the Child. But in doing this, I found myself in a political maelstrom, challenging government policies that are, for the most part, supported not only by the government of the day, of course, but by the opposition as well. And that, I think, poses a threat to a vibrant representative democracy, a very uncomfortable position that was compounded for much of the time, but fortunately no longer, but compounded then by the support for the illegal asylum seeker policies by many in the community. It's very interesting that over these particularly the last 18 months that I've been around the country talking to people, nothing to do with me, of course, but nonetheless, a shift in mood and a shift in a sense of a more humane policy, and I'll come back to that in a little while. But the primary message in my book, and the primary message I have in speaking to this topic about speaking truth to power, is that each of us now, in civil society, in the community, if the legislature and executive government cannot get it right, we have an obligation as citizens to stand up and to speak up for the common law freedoms and human rights that have underpinned our relatively successful multicultural and democratic society. Rights that I believe have gradually been eroded over the last few years. I believe that we've regressed as a good international citizen from those heady days of Doc Evatt all the way through to the 90s. We are now regularly criticised by the United Nations Human Rights Council, just a couple of weeks ago, yet again, for our asylum seeker policies, and in particular for offshore processing. But also, of course, we're criticised by our closest allies, also for the world's highest rates of incarceration of our Indigenous peoples and for rising domestic violence and homelessness. Well, of particular concern to me personally, I'd have to say, is the extent to which women in the public arena are the subject of personal abuse by governments and by segments of the media. Whenever I speak about this issue, I have fresh and disturbing examples to talk about. A month ago, it was the CEO of the ABC, Michelle Guthrie. And a couple of weeks ago, it was Alan Jones bullying Louise Heron, the CEO of the Opera House. Well, I, of course, have had my own day, notoriously, in Senate estimates and other media contexts, criticising the role that I played and hope to play fairly and objectively in the Human Rights Commission. But I do have now 41 cartoons of me that I will take great pleasure in describing to my grandchildren when they're old enough to understand what the devil was going on. The most recent was, in fact, a couple of weeks, so the Murdoch press hasn't given up on me. But I have some wonderful cartoons One of me, I've been shot by the Attorney General, and I'm a trophy on the wall, and he's sitting there at his desk in Canberra with his feet on the desk holding the rifle, but he has in fact also shot himself in the foot. There's another one of me with the entire gang at the Australian Human Rights Commission as a bikie gang, riding the bikes with tats up our arms. And we were there trying, of course. You don't always protect people you necessarily find particularly pleasant. But in this case, we were defending bikie gangs in Queensland who were subject to an additional 25 mandatory sentence years in jail if they were associated with a vicious, lawless motorcycle gang under the Queensland legislation. So that was a lot of fun with my colleagues, but also a cartoon that was my absolute favourite. It was the James Bond cartoon, and it's me, and in all good James Bond movies, at some stage the hero, or in my case the heroine, is dangling from a hook above a shark-infested pool, and in the pool is floating a submarine, which is Mr. Abbott, and sitting on the submarine is the Attorney General in a smoking jacket stroking a cat. Well, I'm dangling by the hook, but I'm clearly going to escape up a rope ladder to a helicopter waiting above. And the running line underneath the cartoon was Triggs, Gillian Triggs. I really like that one. So there were some fun moments, it has to be said, and a huge privilege to work with my colleagues at the Human Rights Commission, and indeed colleagues from the community legal services all over Australia really supported us, along with the Knitting Nanas, the Older Women's Network, and of course Rural Australians for Refugees, and all the many asylum seeker alliances. So it's been an extraordinary time, and I did try to write about it in the book with a chapter really on some of the things that particularly concern me. One being the regressive position of women in Australia. It is really shocking for my generation, educated at the University of Melbourne, down the road, in the 60s, the opportunity, the optimism for women at that time was quite extraordinary. We rode the crest of a wave, imagining that questions of discrimination in employment would be well and truly gone by the turn of the century. But here we are, in the second decade of the 20th century, in a sadly regressive position. We've not achieved anything like as much as in those heady days of the 60s we thought we were going to. We were a bit pretentious. We read Simone de Beauvoir's The Second Sex. We talked about philosophers, Kierkegaard. We, at least metaphorically, burned our bras. We walked behind Jim Cairns in the Vietnam moratorium marches. We had a great time. We had absolutely no idea what we were talking about, but we got in there. We were very politically active, and I think in a way my generation has maintained some of that spirit. But it is shocking now to look at the figures of the World Economic Forum's Gender Index to observe two facts, one of them very positive, and you won't be surprised by it. Australian women, young girls, are the best educated, number one in the world for educational attainment. But we have slipped on the general assessment of political and economic empowerment of women in Australia from 15th 8 years ago to 46th 2 years ago. And there are extraordinary statistics that I find quite amazing. The fastest growing group of homeless in Australia are women over 55. And that brings tears to my eyes even to think about it, that these are women who've often had children, took a lot of time off to raise their families, or with caring responsibilities for older parents, who missed out on superannuation. On average, women have retire on 46% of the superannuation that men do. They've had flexible jobs, casual, unstable work, and too many of them have been forced into levels of homelessness. It's a taboo subject. They stay a few weeks with a son or a cousin or an aunt or one of the other children, but too many of them end up in cars or sofa surfing, ignominiously poor. We have high levels of domestic violence in the community, and one of the highest in the world. I used to be very cautious about saying 1 woman a week is killed by her partner or former partner. The last few weeks have pushed that statistic up to more than 1 woman a week. It is simply shocking, and it's something we need to be dealing with. We have extraordinary lack of job security and casualisation, but we also, at a more general level, have matters that are of particular concern to me, which is the denigration of democratic institutions, including the Administrative Appeals Tribunal, our courts, statutory bodies, the Australian Human Rights Commission, but of course the ABC itself. We have a failure to recognise Indigenous Australians. We have the Northern Territory intervention in which the Racial Discrimination Act was suspended, and we have reports on the Dondale Detention Centre, which led, including reports from the Australian Human Rights Commission, along 2 years later with reports on the Four Corners program that showed the CCTV footage and the picture of that young man, a young Indigenous man, in a steel restraint and a spit hood. And it makes the point for me that while we can, at the Human Rights Commission and many others around the country, conducting serious factually based research to inform policy backed by law, particularly international human rights law, but the common law principles, no man may be detained arbitrarily without charge or trial, and yet those reports sink like a stone in Parliament. And indeed, as is notoriously known, the head of the Legal and Constitutional Joint Parliamentary Committee refused to read the report on the forgotten children. But the extraordinary fact is that that very same problem at Dondale, the use of the steel restraints, was exposed in those iconic photographs and CCTV footage on the Four Corners programme. And the following day, the Prime Minister rings to say, should we have a Royal Commission? I'm sure he consulted many other people than me, but there we are, within a very short space of time. For my generation, the iconic picture was of the young girl running down the streets in Hanoi, escaping napalm burns. For others, it might be the crumpled body of Hélène on the Turkish beach. Well, there's that issue. There's also religious freedom and marriage equality that I'm sure Hugh de Kretser will say a little bit more about, but an extraordinary debate in which attempts were made to suggest that religious freedom is not protected properly in Australia, but also the freedom of speech issue and Section 18C, the very difficult question of whether or not that provision should be amended, and the extraordinary response from Multicultural Australia to ask the Australian Human Rights Commission to stand by Section 18C, a very simple provision. No one may offend, insult, humiliate and intimidate somebody in the public arena because of their race. That is where Australia, more than 20 years ago, under Michael Lavarche, the Queensland Attorney General, drew the line on limits to freedom of speech. The language may not be perfect. It could be all laws can be amended and improved. But the difficulty was that this was so highly politicised that sensible discussion could not really resolve the question. But then we have the problem, of course, of asylum seekers and refugees that really did drive much of my time at the Australian Human Rights Commission. What I attempt to do in the book is to dispel so many of the myths, and the myths is a nice word. Much of it was lies about the law and about the need to detain refugees and asylum seekers. I'm still shocked by the willingness of people to accept the false binary that you need to detain children and their families on Nauru in order to stop the boats and save the drownings at sea. But it was brilliant communication by Mr. Abbott and by many, many others, including the former Prime Minister just last week on the Q&A programme. There is no evidence whatever to indicate that you need to detain children for 5.5 years on Nauru in order to stop the boats or to stop drowning at sea. The boats are being stopped because of an armada at about $1 billion a year of Coast Guard shipping with collaboration with Indonesia, in some cases Sri Lanka and Malaysia, to turn boats around. That and other measures have broken the people smugglers' business model and has effectively created a cordon sanitaire around the north and northwestern parts of Australia. It's a policy, of course, that most Australians support in the sense that we must defend our borders. It's entirely appropriate that we do, and it's entirely appropriate to defend national security. But in my view, we do not do so at the cost of the lives of those 600 or so men that are still on Manus Island, the the hundreds that still remain on Nauru, and about 1,300 that remain in detention in Australian detention centres. The condition of these people... But in a way, what I'm saying is well known to you, and in a way, not only is history, but it remains the position today. But what I find particularly distressing was the statement by our new Prime Minister, Scott Morrison, that all the children will be brought back to Australia by Christmas. A statement made during the Wentworth by-election. Now, when a journalist, in fact, rang me to ask for my comment on that, I perhaps unwisely and cynically said, Scott Morrison made that promise when I was President of the Human Rights Commission and he was the Minister for Immigration some 2 or 3 years ago. It didn't happen. I'm not that sure this is going to be true this time around. And then I thought, no, that's a bit harsh. In the context of the Wentworth by-election, this is a commitment. Those children will be off the island by Christmas. Well, I don't know whether you saw the news today, but apparently Mr. Morrison is now saying that he never made any promise that the children will be back and brought back from Nauru, and that those children that have reached Australia for medical treatment are now being returned to Nauru once they've received that treatment. Now, I'm a bit of a Pollyanna. I'm always optimistic, but I must say I'm deeply, deeply shocked by that news, if true today, that there is a cynical determination that the New Zealand offer, if it's still on the table, it will not be accepted. Now, I want very briefly to say, how has it come to this? How can I run through all of those issues that are a matter of concern to human rights lawyers and to the Australian community? How did it happen? Well, one extraordinary truth is that Australia is the only democracy in the world that does not have a Charter of Rights. Now, I'm not talking about a constitutionally entrenched Charter of Rights, but I think it is time we looked at a legislated charter to provide us with a benchmark which would give the courts the power to ensure that we meet fundamental principles of common law and international human rights law that we've signed up to, as I've said. Not only is that an extraordinary fact, but also our Constitution is one that doesn't really deal with fundamental freedoms, with some exceptions. We have a right to judicial review. We have a right to religious freedom in our Constitution. We have a doctrine of separation of powers. But the kinds of rights that most Australians would think would be in our Constitution, the right to freedom of speech, freedom of association, privacy, the right not to be detained arbitrarily without charge or trial, as old as the Magna Carta, these provisions are not in the Constitution. What I'd like to... the other point also is not only do we not have a charter, and the Constitution is essentially a federal state body, but but the treaties that I've mentioned to you that emerged from those years of the 40s and 50s have, for the most part, never been implemented into Australian domestic law. There are two exceptions, the Racial Discrimination Act and the Sex Discrimination Act. And in fact, I might mention very briefly that one of my colleagues at the Australian Human Rights Commission was the rather marvellous Susan Ryan. And you might recall that she was the first woman ever to be appointed to a Labor cabinet. And when things were a bit grim at the Human Rights Commission, she said, Gillian, go back and have a look at the press cuttings of 1984 when, as Minister for Education in the Hawke government, I introduced the Sex Discrimination Act. And I did. And she was subject to the most extraordinary vilification simply for wanting to give the Convention on the Elimination of Discrimination Against Women a legislative base in Australian law. But most of the other treaties, the International Covenant on Civil and Political Rights, the Convention on the Rights of the Child, the Refugee Convention, economic and social rights, and so on, have not been implemented as part of Australian domestic law. And that means that our courts have a great deal of difficulty in overcoming the legislative provisions passed by Parliament under the principle of parliamentary sovereignty. Now, I will finish, because we want to get on to the other speakers and also to get as much public discussion as we can. But I thought I'd finish on a more positive note. And that is to draw attention to the fact that sometimes we can get it right. And there was a decision by a single judge of the Federal Court just a few months ago, and it concerned one of the many, many cases of children on Nauru with profound medical illness, frequently attempting suicide and meaning it, great cries of distress, and increasing now numbers of children who are not eating properly and are now on a special watch to make sure that they are eating some fluids and staying alive. Many of these children have been the subject of requests by the senior medical officers to the Super Ministry of Home Affairs to bring them back to Australia for medical attention. There are many cases, but one in particular was taken up by these wonderful pro bono litigation lawyers who give their time to these cases, and government officials fight hard against them. But this particular matter was brought before the federal court, asking the federal court to require Mr. Dutton to allow that child, a little 9-10-year-old boy, to come to Australia for medical treatment because he was so sick that there was even doubt that he would survive. Mr. Dutton had refused over 9 months, and his senior officials had refused over 9 months to allow that child to come back into Australia for medical care. But this federal court judge didn't talk about any of the things that matter so much to me. He didn't look at the Convention on the Rights of the Child or go into some statutory analysis of the Migration Act. What he did was to look at the classical Australian common law, developed over millennia. And he said there is a very simple principle of law, and that is that Australia owes a duty of care to these children. They've come within our jurisdiction. They've sought our protection. Most are found to be refugees on Nauru. We owe them a duty of care. We owe this child a duty of care. And he ordered Mr. Dutton and his department to allow that child and his mother to come to Australia for medical attention. But then he did something that I've never seen a judge do before. He checked the flight schedule. And he said, there is a plane tomorrow morning, and I expect to see that child and his mother on that plane. End of judgment. I believe that Mr. Dutton did as he was instructed by the court. So I haven't given up on the law, and I haven't given up on Australians returning to those values that were so important from the 40s up until the 90s. I believe that Australians now are saying, whatever your views, politically or about the need to protect border security or to stop boats arriving with asylum seekers without visas, whatever your views on those subjects, we now have surveys that suggest that about 80% of Australians say that is enough. 5.5 years on Nauru is enough, whatever your views. It is now time to address this problem, whether we do it through the New Zealand offer, but that won't mop up all of them by any means. We need now to face the fact that this is our responsibility, our duty of care, and we now need to respond to those issues. So I have landed, after all of these years, on a very, very clear view that we now need to go back to the idea of a Charter of Rights to provide the courts with more tools to be able to challenge egregious breaches of international human rights law by Parliament and by the expansion of executive powers. So thank you all very much, and I look forward to the other speakers. Thank you. Thank you. Thank you.